Hello, my name is Esma Killick. I'm a solicitor in the Corporate and Commercial Department. I'm here with Stephen James, a partner in our litigation team, and we'll both be giving an overview of some of the key effects of the General Data Protection Regulation, or the GDPR, as I'll call it in this webinar, on commercial contracts. The GDPR is an EU regulation that comes into effect in May 2018. The government has confirmed it will be implemented and continue to apply post-Brexit. Our previous webinars go through current data protection laws and the changes we can expect to see under the GDPR. We recommend you check out our previous webinars to give you a bit more of a background. You can find these on the homepage of our website under the webinars link. Now, turning to the main topic of this webinar, commercial contracts. Some of the changes under the GDPR mean that going forward, certain matters need to be covered in commercial contracts to help protect you and your business. The three key areas we'll be covering are indemnities to protect you financially, transparency provisions so parties are clear on how data is being handled, and safety provisions governing the protection of the data. Until the GDPR kicks in, a controller is primarily liable for a breach of data protection laws. However, under the GDPR, both controllers and processors can be held liable for a data breach and, as a result, be subject to fines and penalties of up to 4% of their worldwide turnover, or €20 million, so around £17 million, whichever is greater. Let's have a quick run through key definitions for this webinar. First, looking at data controllers and data processors. A controller is an individual or a company who collects personal data and says how and why that personal data is processed. And a processor is an individual or company who handles, generally meaning accesses and or uses the data while providing a service to the controller. Think of a third-party IT support provider. And finally, an indemnity means a pound-for-pound reimbursement of your losses and costs incurred as a result of another party's actions. So, why would we want an indemnity in agreements involving data processing? As controllers and processors will both be liable under the GDPR, both parties will want to know they are financially covered if they are slapped with a fine or suffer other losses as a result of the other party's failure to comply with the GDPR. Now, an indemnity in your favour is one way that you can help reduce your financial exposure when entering into a contractual relationship. If, for example, a processor fails to keep data safe and the security of the information is somehow compromised, an indemnity might provide that the controller can recover any or all costs incurred and losses suffered as a result of the processor's failures. If the controller has to pay out under a fine and incurs legal costs, it would have the right to be reimbursed in full by the processor. This can, of course, go the other way too. Because of the joint liability processors will be taking on from May 2018, processors will have greater interest in ensuring that the scope of the controller's instructions are clear and only taking on responsibility to the extent that it is absolutely necessary. And all of this is likely to lead to a lengthier, more complex and expensive negotiation process when it comes to finalising the contractual relationship of controllers and processors. Draft guidance from the Information Commissioner's Office, or the ICO, which is an independent authority responsible for upholding information rights under the law, suggests that the ICO or the European Commission may provide standard draft clauses to govern the relationship between controllers and processors. The ICO is planning to issue further guidance on this area and will keep you posted on any developments. And I'll also leave Stephen to tell you a bit more about indemnities later. The next key point I'm covering relates to provisions on transparency between parties so they know exactly how the data will be treated. Under the GDPR, at a minimum, a contract between a controller and a processor must include the following details about the processing. So we've got subject matter and duration of the processing, the nature and purpose of the processing, the type of personal data and the categories of data subjects being those individuals the data relates to, and the rights and obligations of the data controller. General or catch-all contract clauses are inappropriate, so terms should really be clear and explicit. In addition to these examples, there are also some specific clauses that would need to be included. Clauses providing that a processor may only process data in accordance with the written instructions of the controller, unless, of course, there's another requirement by law. This term should make it clear that it is the data subject, i.e. the individual, who ultimately owns and controls the data. There must also be a clause imposing a duty of confidence on the processor. A processor must provide confidentiality undertakings to ensure that anyone within the processor's organization who has access to and can handle the personal data is also bound by confidentiality obligations to protect the data. Strictly speaking, if such a confidentiality obligation is imposed by the law, then the contract may not really need to be so detailed as to confidentiality, but we would recommend this be covered in the contract anyway for a belt and braces approach. Clauses would also need to cover appropriate security measures, which I'll discuss in a moment as part of my third key area. When it comes to processors using sub-processors, which are basically subcontractors to help processors fulfill their obligations under their contract with the controllers, there are separate specific contractual requirements that must be covered. But in general, we would expect provisions in any sub-processing contract to be just as onerous, covering the same level of indemnities and ensuring primary processing liabilities remain with the main processor. Controllers will also want an obligation on a processor to assist with meeting the controller's own obligations to data subjects, including responding to subject access requests, which we've covered in a previous webinar, requests to rectify or erase personal data, notifying personal data breaches to the supervisory authority or data subjects, audit requests, and, if applicable, carrying out data protection impact assessments, and these are just a few examples. Finally, contracts will need to cover what happens with the data when the contractual relationship comes to an end. These include a processor deleting or returning data. Now, as I mentioned a moment ago, one of the areas that is required to be covered is security obligations, which brings me on to my third key area. Provisions relating to the safeguarding of personal data must be included in a contract. Both controllers and processors must take appropriate technical and organizational measures. These include matters such as anonymization of data, encryption, resilience of processing systems, and backing up personal data in order to reinstate it without compromising security. This could even include adherence to a code of conduct or certification program. As part of this, a controller or processor should conduct a risk assessment. It is worth considering the nature, scope, context, and the purpose of processing data, as well as the risks of breaching data protection laws. The level of security drafted into contracts will take into account the risks presented by processing personal data, including risk of accidental or unlawful destruction, alteration, as well as unauthorized disclosure or access. Now I will hand you over to Stephen, who will cover these points from a dispute resolution perspective.
Thanks, Esma. So I'll be talking about the GDPR in context, and the first thing I'd like to say is much of it might be talked of as codification of good practice. In other words, it contains much of what we should be doing in a properly drafted contract in any event. As a litigation lawyer, I'm only too aware that many disputes arise from shortcuts being taken at the contract formation stage. There might be an initial saving in terms of time and cost by recycling an old document, assuming a one-size-fits-all approach, or even not documenting a contract in writing at all. However, when things go wrong, such shortcuts will lead to a much greater expense, both in financial terms and wasted management time, than would have been the case by drafting the contract properly initially. It may also help to say a few words about the Information Commissioner's Office and their attitude to the GDPR in particular, and what they said about enforcement. A fine can be levied against the data controller in relation to the actions of a data processor if, for example, the data controller hasn't done enough to monitor compliance. Also, understandably, there's a great deal of concern about the headline figures of a maximum fine of 4% turnover or €20 million. But these figures will have very little relevance for the vast majority of businesses. There's a useful Mythbuster section on the ICO's website, and I suggest that anyone who has particular concerns about GDPR have a look at this. I'll quote, for example, myth number 1. The biggest threat to organisations from the GDPR is massive fines. And the answer to that is that the law is not about fines, it's about putting the consumer and citizen first. So in short, the ICO is much more concerned about protecting consumers and helping businesses comply with the GDPR than seeking high-profile prosecutions. Now, in addition to the possibility of enforcement action by the ICO, the GDPR widens the scope for claims for compensation against data controllers and data processors. In order to help individuals bring claims for data breaches, they're able to claim against either the data controller or the data processor and claim 100% of their loss from either party if either the data controller or data processor had any responsibility at all for the breach. Now, to give an example of this, if a data controller was only 10% liable, 10% responsible for what went wrong, the claimant can claim 100% of their losses from the data controller, leaving the data controller then to seek to recover the fair share from the data processor, who was 90% to blame, either through general common law principles or ideally under contractual indemnity. Finally, by way of context, it's worth bearing in mind the potential for negative PR following a data breach for non-compliance in terms of, a data breach or non-compliance with the terms of the GDPR. There have been some high-profile examples in the last year, and it seems quite likely the actual cost of the negative PR would be substantially higher than any financial penalties the parties suffered. I'll turn now to talk about indemnities in a little bit more detail. Esma explained why they're potentially beneficial in a contract that involves data processing. Now, I'll first consider the default position. Although the GDPR introduces joint and several liability for the entire loss, if either the data controller or data processor is entirely blameless, they won't incur any liability. In order to claim against either the data processor or the data controller, you have to show they're at least partly responsible, even if not responsible for everything. It's also important to appreciate that under general legal principles, even where there's no indemnity, there's a right to no contractual indemnity, there's a right to reclaim from the other party their fair share of the liability. In the example I gave earlier, if a data controller pays out 100% of a claim when it was only 10% liable, 10% responsible, it will have a right to recover the remaining 90% from the data processor. However, that process of making the claim can be streamlined by a well-drafted contractual indemnity. The GDPR, I'd say, also brings about the need for enhanced due diligence at the contract formation stage. And I have two things in mind here. The first is it's always far better to avoid a breach happening at all rather than later trying to recover under an indemnity. Indemnities aren't perfect, and invariably there'll be an element of loss that can never be recovered. They also won't prevent the problem of negative PR associated with a breach. As a data controller can incur liability from its data processor's breach, we'd suggest as far as possible checking the data processor's ability in practice to comply with the terms of the GDPR and to build in a contractual mechanism where this can be checked during the operation of the contract. You may also wish to give consideration to financial due diligence when entering into a contract. An indemnity is only worthwhile insofar as it can be enforced. If a data processor goes bust, a data controller won't be able to recover its loss, no matter how well drafted the contractual indemnity is. I'll finish today's webinar by considering what might be negotiated under a contractual indemnity. As Esma says, in due course, we expect the European Commission will produce model contractual clauses, and they might turn out to be the industry benchmark for an acceptable indemnity. Until that time, the terms of indemnity are up for negotiation. At the extreme end of the scale, it would be possible for one party, perhaps the data processor, to grant an entire indemnity to the other with no financial cap for all losses suffered, regardless who ultimately was to blame. I think in practice that's unlikely to ever be agreed, and commercial factors will come into play. It's also worth mentioning what an indemnity for legal costs means in practice. This generally isn't interpreted by the court as requiring the party given the indemnity to pay 100% of the other party's costs. Such costs will still be subject to a review process by the court, but generally they'll be assessed on what's known as the indemnity rather than the standard basis, and that usually leads to a higher rate of recovery than is the default position. Parties should give thought to how contractual indemnities will interact with a general cap on liability within the contract. The party with a benefit in the indemnity may insist on a very high cap, mindful of the very high maximum fines that can be levied under the GDPR. However, I think that the theoretical risk of such a large fine is unlikely to justify departure from contractual limits on liability that would otherwise be in play. It's also important to consider the interaction with insurance policies that might lie beneath the contract. In any event, a contract is a good opportunity to clearly apportion responsibilities between the data processor and data controller. In some situations this may be obvious, but the situation can become blurred in practice, particularly where sub-processors are involved. Finally, we would suggest considering a clear dispute resolution mechanism to quickly sort out matters when they go wrong. Well, that brings us to the end of today's webinar, and we hope you found it useful. If anyone has any questions they'd like to follow up with us, our contact details on the screen there. Thank you.